Welcome, everybody. I'm glad to have you all here for Partisanship and Redistricting, What the Supreme Court Has to Say. I am indeed Wendy Underhill, Director of Elections and Redistricting at the National Conference of State Legislatures. We do have a few housekeeping matters to start off with. First of all, if you don't know the National Conference of State Legislatures, otherwise known as NCSL, we are co-sponsoring this event with the State and Local Legal Center. On behalf of both of those groups, I want to say that we very much appreciate that you are here with us today. This webinar is being recorded and will be made available online both at the NCSL and the SLLC websites in a few days, possibly even sooner. The views expressed in this webinar do not necessarily reflect the views of NCSL or of the members of the SLLC. Speakers' bios and a PDF of these slides are posted in the upper right portion of your screen. That's the little thing that looks like a piece of paper with a triangle in it. Feel free to download those as handouts at any point. And during the presentation, you may ask questions by typing them in the chat box on the bottom left-hand side of your screen. And I'll read those questions to the speakers and participants during the Q&A period. And if we don't get to them all, we'll try to answer them with a follow-up email. If you're having technical difficulties, please send us a message in that chat box, and our operator, Jen, will reply to you privately and help resolve your issue. So first, a little bit about NCSL. Since 1975, we've been the champion of state legislatures. We serve 7,383 legislators and 30,000 legislative staff by providing nonpartisan research and analysis. And we also link legislators with each other and with experts such as those we are so pleased to be able to feature today. And NCSL speaks on behalf of legislatures in D.C. As for the State and Local Legal Center, it files amicus briefs before the U.S. Supreme Court on behalf of its members. Those members are the Big Seven national organizations that represent the interests of state and local elected and appointed officials. NCSL is one of those members, and you'll see the others on this slide as well. Now, as for our speakers, as I've mentioned, their bios are in the resource box, but in short, we'll start off with Michael Kimberly, who is a partner at Mayer Brown and co-director of the Yale Law School Supreme Court Clinic. And he'll be talking about the Maryland case, Benisek v. Lamone in particular. Then we are pleased to have Paul Diller, a professor of law at Willamette University College of Law. And we'll give the last word to Misha Tseytlin, the Solicitor General in Wisconsin, who defended Wisconsin's redistricting plan. And with that, if you're ready, I'll hand over the webinar to you, Michael.
Great. Thanks, everyone. So I've just turned on my cursor so that hopefully everyone can see where I'm pointing. I'll be pointing at a few points. I've got 12 minutes to talk. I'll try to make as efficient use of that time as I can. Here's a brief overview of the things that I'd like to touch in that time. First, just a brief description of gerrymandering, what it is and what happened in Maryland in 2011. Then I'll briefly touch on the problem that has troubled courts over the last 60 years in addressing partisan gerrymandering. I'll briefly describe the approach, the legal approach that we've taken in our case in an attempt to solve that problem, and then I'll say something briefly about the status of our litigation. So I think as probably most people on this call understand, partisan gerrymandering is about drawing district lines in such a way as to weight the outcomes, deliberately weight the partisan composition of a district in an effort to dictate electoral outcomes. This slide here shows that in a state with 60% blue and 40% red, it's possible to draw district lines such that all 5 districts go to the blue party, or alternatively that 3 of the districts go to the red party, despite that the red party has 40% of the vote, and 2 go to the blue party, despite that it has 60% of the vote. This is relevant to the litigation in Maryland. I'll mention that partisan gerrymandering depends on the factual premise that, for the most part, voters do tend to congregate in particular areas so that geographic blocks of the state typically will vote in one direction or another. That's what makes gerrymandering work, partisan gerrymandering work, so that you have a red box and a blue box and a blue box and a red box, allowing you to segregate voters on the basis of the way they have voted in the past. Now I'm going to quickly show a video that demonstrates what happened in Maryland in 2011. Our lawsuit concerned, let me pause here a sec. Our lawsuit concerned Maryland's 6th congressional district. There are 8 congressional districts in Maryland. The 6th district has historically, since it was first drawn in the 18th century, comprised northwest Maryland, which, as you can see, has a panhandle that extends into the space between West Virginia and rural south central Pennsylvania. In this map, the small dots that you see here indicate areas of high population density. So as you can see, the 6th congressional district has very low population density and historically has been a very rural district. This is roughly the way the district looked from 1990 until 2000, and it reliably elected a Republican candidate. This now in blue is what the district looks like today. And as you can see, what the map drawers did is they extended the district southward towards the suburbs of Washington, D.C. And this today is what the district looks like. Now, I understand there's a bit of a lag in the video, so I'm going to give everyone just a moment to catch up on the presentation. I'll skip that slide. So to give everyone a sense of what, as a practical matter, this accomplished, Washington, D.C. is down here as the blue dot in this depiction. You can make out the lines of Maryland here, which shows the size of the district. And there's a town up in the northwesternmost corner of the state called Friendsville. And as the crow flies, which is not to say as you would have to drive on the interstates, which would take much further, as the crow flies, Friendsville in Maryland's 6th congressional district is about equidistant between Washington, D.C., which is just 6 miles from the 6th congressional district, from the southernmost point of the 6th congressional district, to Akron, Ohio. So this has made the 6th district has linked parts of Maryland that are socioeconomically extremely different, and just as a matter of geography are very far apart. So what was this all about? Well, in 2011, Maryland's 6th congressional district was overpopulated by about 10,000. And what that, of course, under the one-person, one-vote rule, congressional districts have to be drawn every decade such that they have equal populations. So the map drawers had to subtract 10,000 voters, residents from Maryland's 6th congressional district. And to accomplish that, what they did was they removed 360,000 and added 350,000. The rough population of the district was 750,000 people, and so this was shuffling roughly half of the district's population. And it was no coincidence that among the areas that were moved out, there was a strong lean in favor of Republicans. There was a 66,000 voter advantage in terms of registered Republicans in the parts that were moved out. There was a 24,000 voter advantage in favor of registered Democrats for the parts that were moved in. And the net result was a 90,000 voter swing in favor of Democrats. And that's only among registered Democrats. This part of the state, independent voters vote overwhelmingly for Democrats as well. So in fact, it was a larger swing than this, than just the registration suggests. And to put this into perspective, in each midterm year, about 270,000 people vote. In presidential years, it's closer to 330,000. So a 90,000 voter swing is a change in a massive portion of the voting population. And the results in the 6th district were as intended. We focused in our case not on statistical measures of overall balance of a map, which I know Misha and Paul will be talking about later. We focused instead just on the 6th district and therefore just on the sorts of measures that the map drawers themselves were using to try to flip the 6th district from Republican to Democrat. And what those metrics showed was that before the gerrymander, the district was almost 100% likely to be won by a Republican, and after the gerrymander, it was 92 to 94% likely to be won by a Democrat. And indeed, that's just what happened. Republican Roscoe Bartlett, who had been the incumbent since 1990 and had won all of the more recent elections by 15 to 25% margins, and in the very most recent election had won by a 28% margin, was defeated in 2012. This time he lost by a 21% margin after the gerrymander. And so the map drawers, we contend in our litigation, effectively flipped the 6th district from a reliably Republican to a reliably Democratic district. Now I see I'm already pushing my time limit, so I'll just say the threshold question in these cases is whether partisan gerrymandering is even the kind of case that is suitable for resolution by a federal district court. And the question really turns on whether it's a political question that the Constitution commits to the Congress or the executive, or instead if it's the kind of question that is appropriate for a court to resolve. We have suggested that under the First Amendment retaliation doctrine, it is appropriate for courts to resolve. Courts are faced with First Amendment retaliation cases all the time. First Amendment retaliation encapsulates the idea that state officials cannot retaliate against individuals for expressing themselves in ways that are protected by the First Amendment. And drawing on statements that Justice Kennedy had made in a 2004 case called Veith against Jubileer, we argued that that's what partisan gerrymandering does, that the decision makers in the Democratic decision makers in Annapolis looked at the way that voters in the old 6th district had cast their votes, looked at the way that they had participated in the electoral process and political process in support of Republican Roscoe Bartlett, and they disapproved of that conduct and set out to make it impossible for them to re-elect Roscoe Bartlett as a consequence. Technically speaking, the burden that they imposed, we argue, is vote dilution, which is also a familiar concept in a Voting Rights Act and racial gerrymandering cases. These are all concepts that courts are familiar with, and we think they have the tools to resolve these cases. And in a case called Shapiro against McManus, which is the same case, Benisek against Lamone, it was just recaptioned later, we persuaded the 3-judge district court that we were right. That court adopted our proposed test. It said that there's no First Amendment retaliation exception in redistricting, and therefore we had stated a claim. And it established 3 elements: that we had to show that those responsible for drawing the map intended to target people because of their party affiliation and voting history, that they succeeded in imposing a practical disadvantage in the electoral process as a consequence, and that the map drawers would not have drawn a map that otherwise diluted the targeted voters' votes. So briefly, where things stand in our case, we developed, I think, a great record in our case that demonstrated all of the facts that we need to prevail. We sought a preliminary injunction, which is an injunction in the middle of a lawsuit before the lawsuit is completed, and that request for preliminary relief was denied. We appealed that, and I had hoped that the Supreme Court would reach the merits of our claim when we then appealed, but as it turns out, the Supreme Court was unable to reach a consensus on what standard it thought should govern, and ended up punting on the merits of our case. It affirmed the denial of a preliminary injunction on technical timing grounds that were relevant to the preliminary injunction standard and not really the merits of our claim. And so our case is now back down before the district court. We are now asking the district court to enter a final injunction. We are likely to have a trial in our case, which will probably focus on the expert evidence. We're presently waiting a decision from the district court on summary judgment, and shortly after that hope to go to trial.
Michael, you did a remarkably good job of trying to stay on time there, and I will point out to everyone that these slides are available to you, so you can read through them again for a review as you need to. Thank you very much, Michael. Paul, I'm going to turn it over to you now.
Hi. Excuse me. Good morning or good afternoon to those on the East Coast. I am going to talk about Gill versus Whitford, and then I'll talk a little bit about the basics of the case and how the decision came out in the U.S. Supreme Court, and then I'll also talk about an amicus brief that I co-wrote on behalf of several law professors who specialize in local government law and some local government organizations like the International Municipal Lawyers Association. So Gill versus Whitford started off as Whitford versus Gill, actually, was a challenge to Wisconsin's legislative redistricting of 2011. Like the previous case, it brought up the First Amendment, but it also brought up 14th Amendment equal protection arguments against what it alleged to be intentional political gerrymandering of state legislative lines. So in Wisconsin, like in most but not all states, drawing up state legislative districts is a responsibility of the state legislature. There are some states that farm this duty out to independent commissions, but Wisconsin does not. And so in Wisconsin, after the 2010 midterm elections, Republicans controlled both houses of the state legislature and also had a Republican governor, which set up the possibility of, at least, of a state House and state Senate districting plan drawn up more on partisan lines. The plaintiffs in Gill argue that it was an intentionally partisan plan that was designed to pack Democratic voters into fewer districts that they would win more overwhelmingly and allow Republicans hold on to a seat majority despite changes in the overall statewide vote for state House or state Senate. The district court agreed with the plaintiffs and found that there was evidence of legislative intent to secure Republican control of the legislature for the decade, and it also found evidence of a discriminatory effect. And you can see on the screen some of what the district court found. Now, a big part of plaintiffs' theory was using a metric to measure the effects of gerrymandering called the efficiency gap. It's a concept that is rooted in a law review article written by a couple of academics, Nick Stephanopoulos, who was also one of the litigators in Gill versus Whitford from the University of Chicago, and Eric McGee. And I'm not going to get into details of the efficiency gap. We have some supplementary materials that do. I recommend taking a look at them if you're not familiar with the concept. But long story short, the efficiency gap essentially tries to measure the proportionality of wasted votes. Under a particular districting scheme, is one party losing more votes, not translating as many votes into seats as the other. It's not the same as proportional representation, even though its opponents sometimes refer to it that way. And so using this metric, the plaintiffs show that the Wisconsin plan had high pro-Republican efficiency gaps in 2012 and 2014, meaning it was effective at causing Democrats to waste votes overall in elections. Based on all of this evidence, the district court holds that the Wisconsin plan did violate the 14th Amendment equal protection. The dissent, this was a three-judge panel at the district court level, the dissent tried to argue that the efficiency gap and some of the plaintiff's theories really were trying to make out a claim of proportional representation, and so he brought that up in objection. So this goes to the Supreme Court, and for many years, the Supreme Court, there were some justices who said, we don't recognize a claim for political gerrymandering at all. It's not justiciable. Other justices, particularly Justice Kennedy, had hinted, well, I'm open to the concept if you can just figure out a good metric for determining whether it has occurred or whether it's gone too far. And that's what the plaintiffs thought they had in the efficiency gap. And so going into the case, a lot of people thought the court would be divided, maybe come out 5-4 either way. It turns out unanimously the court holds that the plaintiffs lacked standing to challenge the entire statewide map because the plaintiffs were only 11 residents of Wisconsin who lived in 11 different state assembly districts. Wisconsin has 99 assembly districts, and that means 88 of them were not represented, but the plaintiffs were challenging the entire statewide map. Justice Kagan concurred along with 3 other justices and tried to leave the door open for a future suit under a more of a First Amendment theory like we heard about earlier. I see the decision, while on its face a technical decision just based on standing, it really cuts against the plaintiff's theory under the efficiency gap, which is that a harm to a Democratic voter in one district is a harm to a Democratic voter statewide if the entire map has been drawn up to hurt Democrats and likewise Republicans if that were the case. So while it doesn't rule out the possibility of making out a case using efficiency gap type analysis, it means you will need a larger case. If the plaintiffs want to bring the same kind of challenge in Wisconsin, they're going to need 99 plaintiffs, and that may or may not prove unmanageable. And so perhaps we will see more federal constitutional litigation under the First and 14th Amendments in state legislative districting. But I think we're also likely to see more focus on reforming the districting process in states that have the initiative. And what you've seen in places like California and Arizona, where the voters have voted to divest districting, the responsibility for districting from the legislature, and give it to an independent or nonpartisan or less partisan commission. And you're also going to see some more litigation under state constitutional provisions, like we saw in Pennsylvania, where the state Supreme Court held that the U.S. House districts in the state had been intentionally politically gerrymandered under the state's right to vote provision, so not under the First or 14th Amendments of the U.S. Constitution. Now, I'll talk briefly in my remaining about 5 minutes about a different angle that our team brought up in our amicus brief, and that was the effect of what we argued was the effect of gerrymandering, a potential effect of gerrymandering on local government authority. As you may know, local governments are seen as subservient to the state under the federal constitution. So it's a little more complicated under state constitutions, some of which recognize home rule, but the federal constitution allows states to preempt local governments, to take power away from them, to deny them funding. None of those actions are, at least on their own, federal constitutional violations. And so, nonetheless, the Supreme Court has, in a variety of cases, recognized the importance of local government to our constitutional order. And so our argument was that another potential effect of intentional partisan gerrymandering is that it can lead the state legislature to take away power from cities who are not of the same partisan orientation of the majority in the state legislature. And so we looked at a number of states where you have sort of urban-rural tensions that are exacerbated by political gerrymandering. And the ones we looked at in particular in the brief are Florida, Michigan, North Carolina, Ohio, and Wisconsin. We picked those states because they had efficiency gaps of 10% or more in 2012 or 2014, and because they had other indicia of partisan gerrymandering like a legislative district drawing that was controlled by one political party. And these are some of the areas where we've seen a lot of preemption by state legislatures of local power in the last 5 to 10 years. And these are some of the new methods of preemption. This is something you can read more about in this particular issue brief that you can see on the screen right now. And so we looked at Wisconsin and some of the, of course, the plaintiffs were arguing Wisconsin was, in violation of the Constitution through its evidence through their evidence of intentional political gerrymandering. And we looked at some of the preemption that had occurred in that state, including municipal employee residency requirements and preemption that preceded gerrymandering, like local minimum wage and paid sick leave. And then we went through other states, I'll go through this quickly as my time is running out, like Florida, Michigan, where you had the state legislature stripped local city councils and mayors of all their authority, as seen in Detroit and Flint, where emergency managers were put in place. North Carolina, Ohio. And so the question is, what does Gill mean for local governments? Well, if the theory of our brief was correct, that intentional political gerrymandering is harmful to local governments, then local governments ought to support state reform efforts, like some of the ballot initiatives I referred to earlier that would promote more neutral districting processes, and they might also seek to support state constitutional litigation, like we're seeing in Florida and Pennsylvania. And then at the federal level, you're seeing proposed something called the Fair Representation Act, which is an attempt to cut down on gerrymandering of U.S. House seats, and that might help remedy any harm that cities may feel they're suffering from gerrymandering of U.S. House seats at the federal level. For more on that, I have a couple of links here to fairvote.org and also an article I wrote that talks about how gerrymandering has harmed urban areas, not just at the state level, but also at the federal level. I see somebody's asking for a link to the amicus brief. There is a link on one of the earlier slides, so you can go back and find that later. Happy to take questions, and I know I've crammed a lot in and had to skip over some stuff like the efficiency gap, which probably could merit an hour in and of itself. But thank you, and look forward to the Q&A.
Paul, that was just great. I really appreciate your clarity on all of that, and that your slides give us some things to go back and look at. You did mention a law review article. We do have that up in the resource box that describes the efficiency gap, and NCSL has a statewide ballot measures database that has information about all of the ballot measures this year related to shifting from legislative control to commissions. I will say that 2 of those, Colorado and Ohio, were put on the ballot by the legislatures. But anyway, we'll have some more stuff up on that ballot measures piece. With that, let's shift over to you, Misha. Thank you.
Thank you so much, and thank you for having me on. I'm not going to do any PowerPoints. I'm just trying to chat with everyone about our case, the Gill versus Whitford case out of Wisconsin. And I'll chat very briefly about the Maryland case, and then I'll give some thoughts on potential litigation going forward. First, as was alluded to in Paul's presentation just now, Gill involved a statewide challenge to Wisconsin's map based upon the efficiency gap concept. The challenge was brought to our entire map because our individual districts are just fine in terms of traditional district criteria and things of that sort. So they had to come up with a statewide challenge of some sort based upon statewide vote-to-seat ratios and the partisan symmetry metrics, which are just a rough way of doing proportional representation. Now, when we came to the U.S. Supreme Court, we made a couple of categories of arguments, and I'll describe them briefly because I think they do a good job of framing the issues both that the Supreme Court decided and the problems and potential opportunities for litigation going forward. First, we argued, and this was our lead argument, that the plaintiffs lack standing to bring a statewide claim. And I think in some of the comments earlier and some of the questions that I'm seeing here in the chat, there's a little bit of confusion as to what the standing problem was that we were identifying. The problem isn't that there wasn't a plaintiff from every district. Is that it was that the harm alleged was a statewide harm. There wasn't any showing of harm to the individual district. And I think the most obvious example is the one we talked about both in the briefing and that the Supreme Court talked about in its decision, which is the lead plaintiff in our case, Professor Whitford. Now, Professor Whitford lives in Madison, which those who know a little bit about Wisconsin is a very democratically dominated area. So Professor Whitford would live in a Democratic-dominated district under any plausible map, the map that was used, any of the maps that were proposed by anybody else, including by the plaintiffs. So what we were saying is that in order to bring a challenge to districting, you have to show a harm to your own district. And we pointed there to the racial gerrymandering cases. In the racial gerrymandering context, if you believe that your entire state was racially gerrymandered, the Supreme Court has said unanimously that you can't bring that kind of claim. You can only bring a claim to your individual district because you as a voter live in your own district only, vote in your own district only, and you can, and as a result, you have only a generalized interest in what happens in the rest of the state. Now, when the Supreme Court ultimately decided the case, it ruled unanimously that our argument was correct, that the plaintiffs had no standing to bring a statewide claim. And while the court did focus some of this discussion upon the specific failings of proof that the plaintiffs made, I think the court's reasoning effectively puts an end to statewide political gerrymandering challenges. And it puts any future gerrymandering challenges, if they were ever to be recognized at all, in the district-specific box. Exactly what's done in the racial gerrymandering context. And I think just taking a step back, that just had to be the rule that came out of Gill v. Whitford. Because imagine if the situation was reversed. Imagine if the Supreme Court had recognized statewide political gerrymandering challenges when they did not recognize racial gerrymandering challenges. And suppose you have a state in the South where race and politics are correlated. Under the plaintiff's theory, if you could show that your map drawers were focused on race, you would only get a district-specific challenge. But if you could show that the map drawers were focused on politics, you would get the holy grail of a statewide challenge. And whatever one thinks of political gerrymandering, it certainly is not as serious as a claim of racial gerrymandering. So it would be perverse and I think quite nonsensical to say that when it's already unanimously established that you can only have district-specific challenges for racial gerrymandering, you should somehow get statewide challenges for political gerrymandering. Now, I will then talk about another argument that we made in our case, which the Supreme Court didn't decide, but I think sheds important light on redistricting going forward. We argued that the test that was being proposed in our case, the Wisconsin case, was too malleable, too overbroad, and politically biased. Now, with regard to malleability, we argued that the efficiency gap, or the test that the plaintiffs proposed, was dependent on so many different kinds of metrics that the plaintiffs could pick and choose from, that every single map that was drawn by a party under single state control would automatically be challenged in court as a partisan gerrymander. And the outcome of that case would be quite uncertain. It would depend to some extent on what judges you happen to draw, and the legislature wouldn't know in advance whether its map would survive a partisan gerrymandering challenge. And we made this argument in our case in Wisconsin, which was argued in October. And I think we saw the most clear vindication that we were correct when the Maryland case came along. When the Maryland case came along, the plaintiffs from the Wisconsin case came in and filed an amicus brief in the Maryland case. They said, hey, Supreme Court, the Maryland approach, adopted or not, but we want to point out to you that the Maryland map as a statewide basis under our partisan symmetry metrics would fail the test. Now, what was so interesting is that when their own expert discussed the Maryland map in a different case, the North Carolina case, their expert had said that their map would survive under a partisan symmetry challenge. Now, I'm not saying that their expert was wrong before or right before, or that they were wrong in front of the Supreme Court and the expert right. I think what that shows is that we were exactly right, that the reliance upon social science metrics that the plaintiffs can pick and choose to fit their particular case, that and that the baseline can be picked and chosen for a particular case, will lead to maximum malleability and overbreadth, because the legislature will never know which metric is going to be used against them in the case, and they won't know how the challenge will come out until after a uncertain and costly trial. And then another important argument we made against these partisan symmetry metrics is that they are politically biased under modern political conditions. And I think it's very important for folks to understand why exactly this is the case, because I think it goes a long way to show why, even though the notion of partisan gerrymandering and objections to partisan gerrymandering has been around for a long time, indeed since the founding, why there's a rush towards litigating them now. It's because that there is a particular theory, this partisan symmetry theory, that happens to well align with the interests of one of the two political parties in this country, which is the Democratic Party. And I think the easiest way to see why that is true is to take a look at the state of Illinois. Now, Illinois, in the colloquial sense, is the kind of paradigmatic case of a Democrat gerrymander. The Illinois Democrats, when they took control of the legislature, made the most democratic map possible. And this was, the evidence is undisputed. But the fact of the matter is because so many Democrats are naturally packed into Chicago, that map scores neutrally on partisan symmetry metrics. It scores as a completely neutral map. So you can see why this would be so attractive to one of the two political parties in this country, when the other side's gerrymanders are scored as egregious gerrymanders because they are just increasing partisan advantages that they have because their people don't live in major cities. Whereas your own gerrymanders are scored as completely neutral because they're canceling out geographic disadvantages. If the courts adopt that, then you get a bonanza. So anyways, moving quickly on to the theory that was proposed in the Maryland case. I think that theory solves some of the problems that I've identified, but it doesn't solve the most important one. It does solve the problem that the challenge can be brought district-specific, as Michael described. It also solves the problem that it doesn't seem to be particularly politically biased. But I don't think it solves the fundamental problem of having an administrable test that won't cause uncertain litigation for an untold number of districts. When the case came to the U.S. Supreme Court, the fundamental challenge for the challenges to the Maryland district was how can you tell if a single district is gerrymandered or not? And since political intent will generally exist whenever you have politicians drawing maps, it comes down to partisan effect. And what the plaintiffs said in their briefing in Maryland is anything more than, quote, de minimis partisan effect is enough. And this can be measured by any number of metrics, any number of political prognostications. So I think it's quite easy to see what would happen if that was ever adopted. Is every single district drawn by a political party would be challenged. The plaintiffs would find an expert, would find the particular metric on which they would do best. The defendants would file their own expert, and you would have uncertain litigation, which no one would be able to predict in advance. So where does all of this lead us? I think there is, in the future, a good chance that the Supreme Court will hold that all partisan gerrymandering claims are non-justiciable because they have not been presented with a limited, precise, judicially administrable standard. And I think there's frankly some frustration on the court about the type of standards that have been presented to them. I think, in my personal opinion, they tend to overreach. They tend to either create a bonanza for one political party, like the efficiency gap, or they set up a standard that's way too easy to satisfy, like the de minimis standard. So if the court is not going to close down political gerrymandering entirely, I think successful plaintiffs will have to propose a test that satisfies a couple of criteria. One is that this test is going to have to be district specific, so you don't have this unthinkable mismatch with the racial gerrymandering cases. Second, it has to be a test whose effects prong has to be able to be told in advance, so that when the legislature is drawing the map, it should be able to know whether its map would be its district would be subject to a challenge. It should be kind of thing like the one person, one vote cases, where you can apply the test ex ante. 3, it has to be political neutral. It can't be systematically biased towards one of the two major political parties in the country. That's just a non-starter. 4, it has to be historically grounded in some respect. It can't be a novel invention of modern social scientists. It has to have some link to founding thought or founding principles about what fair distribution is all about. And 5th and finally, it can't be overbroad. It can't be the kind of test that would knock out 1/3 of all maps in the country, that would subject the majority of districts in the country to uncertain litigation. It has to be limited and precise, in Justice Kennedy's words. And with that, I will end my discussion.
Well, thank you very much, Misha. A couple of thoughts before we move on to questions. One is that I think you just told us that if you were looking in your crystal ball, that you think that the Supreme Court may well hold in the future that partisanship is not justiciable. I don't know if I can pronounce that word right. I'd like to ask Paul and Michael if you have some thoughts about that, and if you don't want to weigh in on what you think the court might do in the future, that's perfectly fine too. Paul, I'm going to go to you first on that.
Thanks. Well, I agree with Misha that the 5-justice majority opinion in Gill versus Whitford probably does put an end to the efficiency gap analysis. I mean, part of that 5 justices was Justice Kennedy, and we may have a new justice in Justice Kavanaugh, and I don't know if he's waiting on these kinds of matters. Probably the guess on the street would be that he would be averse to these kinds of claims. So just looking at the court's composition, it does seem unlikely that the efficiency gap type analysis will succeed. Could succeed maybe a little more than some of the lower courts, but eventually at the Supreme Court it might not do so well. But just to pick up on one thing Misha said, the argument that the plaintiffs were trying to make was that even if Mr. Whitford lives in Madison and Madison is always going to vote for Democrats, he's still hurt by gerrymandering way far in the north of the state because he can't get the kind of policy coming out of the legislature that he prefers. That was the theory, and that theory didn't work. So, yeah, I think it doesn't look great at the Supreme Court moving forward.
Thank you. And Michael, do you want to weigh in on what the Supreme Court might do in the future? You don't have to.
Yeah, no, sure. I'm happy to say something about it. I'm a realist, and I think anybody who doesn't have a sense that there's at least a real possibility that the court would close the door on partisan gerrymandering claims sometime in the near future probably is looking through rose-tinted glasses. I think the Supreme Court in 2004 in Vieth against Jubileer had really set up, I think, 2 different ways of thinking about partisan gerrymandering, and they were the 2 different ways that were reflected in the Wisconsin litigation and in the Maryland litigation. The one was this concept of partisan symmetry embodied in Gill in the efficiency gap, and the second way of thinking about it was First Amendment retaliation. I think there was a lot of cautious optimism, certainly going into the Gill argument. I think by the time the court had noted probable or postponed probable jurisdiction in our case in Maryland, there was a sense that the justices were probably going to rule against the plaintiffs in that case on standing grounds, because if the court were getting ready to approve the theory in that case, they wouldn't have had a need to take our case. And so I think that optimism was dampened when they noted probable jurisdiction in our case, but folks were still hopeful. The difficulty now moving forward, though, is that our theory, the First Amendment theory, was in some respects tailored to Justice Kennedy, who was the one who most forcefully described it in his concurrence in Vieth. And now that he is no longer going to be on the court, it's unclear just how receptive the new majority will be to that theory moving forward. I think certainly Justice Kagan, in her concurring opinion in Gill, did her best to keep the hope alive and to lay out the kind of First Amendment concept that she and her 3 Democratic-appointed colleagues might find compelling. I think it's a little bit different from the kind of approach that Justice Kennedy had proposed in Vieth. But there may yet be hope there. I think it comes down to what the court looks like after this next round of redistricting, because I think we're going to see partisan gerrymandering on steroids in 2020 and 2021. And if there's going to be a hope of winning any of these cases, I think it'll be after that, and it'll depend a lot on what the court looks like then.
We had a question from Grace, and I think it relates, it's a good follow-up here. She asks, if 11 districts are gerrymandered, wouldn't the practical effect of fixing those districts result in changing most, if not all, of the state map? You've sort of addressed this, but her follow-on, if so, then do you really need 99 plaintiffs? Michael, if you could just say, is it possible to pull 99 plaintiffs together and take this back again?
Yeah, sure. I think it is possible to pull together 99 plaintiffs arguing that each of their individual districts was gerrymandered. I do tend to agree as a practical matter that if the interest is in drawing a map neutrally and redoing the entire map, you really wouldn't need 99. You could gather a handful, maybe 10, or in a state like Wisconsin with 99 districts, you could probably gather 10 or 15 well-placed plaintiffs with very strong claims, and as a practical matter necessitate redrawing the entire map.
Great, thank you. Paula, I've got a question from you, from Greg. Why use metrics like the efficiency gap, which are sensitive to idiosyncrasies of individual candidates or elections, as opposed to partisan registration? And we had some chat about this. So could you take a look at that for us?
Sure. I did see that question pop up. I'm not sure how sensitive. I guess I disagree with the premise a little bit. I'm not sure that the efficiency gap is that sensitive to idiosyncrasies of individual candidates, particularly when you look at it across time. Arguably one of the disadvantages the plaintiffs faced in Gill was they were only looking at 2 sample sets of data under the efficiency gap, 2012 and 2014. There was some more data, some good data that came out from the Associated Press analyzing the 2016 elections and using the efficiency gap, but that wasn't part of the record in Gill. So why use the efficiency gap and not partisan registration? Partisan registration is often not that useful at telling us what voters want. Until just a decade ago or so, the Democrats predominated in the South in partisan registration. In states like Kentucky, I think they still do. And those are, red states when it comes to at least presidential elections. So I think the plaintiffs thought that the efficiency gap was a better metric for showing what voters want, because it is based on how they have voted in district elections.
Great, thank you. I've got a couple of other questions for everybody. And Paul, I'm going to go to you next, and then I've got one more for Michael and for Misha. Paul, what is it that local governments can do? How can they have a say in redistricting at the state level, or should they even have a say at the state level?
Well, as the folks at NCSL know, of course, local governments lobby, and so local governments can ask for a seat at the table. whether it's just the post-census districting process that a state like Wisconsin engages in or will engage in 2021, or if it's like what was mentioned earlier, drawing up a new system for districting, then I think local governments can try to have a seat at the table and lobby for that, and argue or urge a system that would be fairer and more protective of their interests.
Great, thank you. Paul, I want to go back to Benisek for just a minute. I think part of the argument was that this case was being argued in 2018 and the maps were drawn years ago. Do you think the court would have been more receptive to the case had it been brought 5 years earlier?
I think you meant Michael, right?
I did mean Michael.
Yes.
Oh, yeah, okay. I was happy to hear what Paul had to say about that.
I dodged.
Sorry, guys.
The honest truth is I think the nature in which the Supreme Court resolved our appeal in Benisek was a reflection not really about its concern about the timing, but the fact that they couldn't reach a consensus on the merits. I think if there had been 5 votes to adopt our merits theory as it was presently queued up and presented to the court, they had everything they needed to do it. I think there are a lot of sort of idiosyncratic reasons, idiosyncratic to the time of year, to the term, that explain why Justice Kennedy may not have been sufficiently satisfied or motivated to run with our case. I'm skeptical that if it had come up in 5 years, though, unless for really unpredictable reasons, I'm skeptical that it would have come out differently. And just to explain a little bit what I mean by those unpredictable reasons, it's really interesting to compare the oral argument in Gill against Whitford with the argument in Benisek against Lamone. Gill against Whitford was, the third or fourth argument of the term. The justices were fresh off their summer break, and they were, getting back into what looked like an exciting term together. By March 28th, near the end of the term, when I argued the Benisek case, I think it was very clear that the justices were a bit more impatient with one another. By then, they had been working on numerous 5-4 opinions. I wouldn't go so far as to call it acrimony, but it was not an especially friendly exchange among the justices. And on top of that, Justice Kennedy was nearing the end of the term, and surely by then had decided that he was going to retire, and I think was understandably beginning to draw back from his engagement in these cases. And so, for those sort of completely unmerits-oriented reasons, is it possible that if the case had come up 5 years ago, it might have come out differently? I suppose so. But short of that, I think probably not.
Great. I'm going to make the last question from Misha a 2-part question, and both parts are a little tricky here. The first part is, given that the census is just 2 years away, how likely will the current cases become moot before they can finally be resolved? And the second part that doesn't really relate at all is, what can you share with us about what Justice Kennedy's legacy on redistricting might be?
Well, thank you. In terms of the cases becoming moot, the North Carolina case, which was sent back in light of Gill and Benisek, has a very active 3-judge panel who's already asked for a very quick supplemental briefing. I think that case will get up to the U.S. Supreme Court in short order, and that case purports at least to have both statewide and single district claims, although I don't see them as actually having a robust single district theory. So I think that the issue of statewide political gerrymandering claims, I think there's a good chance that that's going to get resolved, and I think that's probably going to get resolved in the negative to the challengers. Whether single district claims will get resolved fully by 2020, I think probably not. I think there's still a lot more to go, a decent way more to go on that. I think Michael obviously has one theory. I think there are other theories that will be tested once kind of the the fever for partisan symmetry and the efficiency gap passes, and folks start thinking about other ways to approach this, perhaps consistent with some of the comments that the Chief Justice made at Michael's oral argument, which might point a way towards a single district claim that maybe he'd be willing to consider. In terms of Justice Kennedy's legacy on redistricting cases, obviously he left the door open for a potential partisan gerrymandering claim, contrary to 4 justices who wanted to close off the path in Veith. And what he said there is that perhaps the time will reveal eventually that judicially manageable standards cannot be found, but perhaps that is not so. And I think whatever happens here, I think it will have borne out the wisdom of what he said there, because I do think he was correct that the time between Vandermeer and Veith, which is 30 years at that point, was or even less than that, was a short time in the law. And I think that the courts did need a little time to the common law method to figure out whether, in fact, judicially manageable standards can be discovered. My personal view is that both in the 2 cases last term, the litigants did not I think, come up with standards that I think are judicially administrable. I hope that as folks explore further, more standards are proposed and considered, so that the court can take a whole view of all the potential standards that could be proposed. So they can either adopt one of those standards, or they can say, well, we've allowed the best to take place, and no standard can be discovered, and we are going to end this litigation. I think Justice Kennedy's legacy in this area will be to have had that conversation take place over a longer period of time, and the right decision, I think, will be reached at the end of that conversation.
Thank you very much. And now we have reached the end of our webinar. And if you could all just pretend, the speakers, if you could pretend we're all clapping for you, hear the applause, because we do appreciate what you did. And everyone, if you could just wait for a moment, you'll be directed to a short survey so that NCFL and SLLC can learn what your needs might be for future webinars. And with that, I'm going to say thank you to everybody, and please do be in touch with us.